When a divorce is filed, the case can only end one of four ways. Okay, there's really only one of four possibilities, and we'll go through these. One is the parties agree on all the issues, so you agree on everything, right? You want the divorce, you agree on how you divide the property and debt, you agree on child custody, child support, spousal support, and you put settlement documents together. Both parties signed it, agreed to it, and that's way one. And I can tell you, I mean, I've been doing family law 14 years. It's all we do at our law firm, Stange Law Firm. We've got 8 offices in the St. Louis metro area. So we've got, you know, a huge volume of cases. But I can tell you, in saying that, if I took a survey of the people that came through our firm, I mean, this is where 90% of the people want to be easy, right? Everybody wants to settle the case. Who wouldn't, right? Who would want to have a contested, nasty case? Nobody does. Right? The problem is on the front end is if parties were able to compromise, they might not be getting divorced in the first place. Right? That's the whole issue. Right? I mean, when that divorce process begins, people aren't getting along. There's not, unfortunately, not a whole lot of feelings of love and harmony and all that kind of stuff out of the gates. And so, you know, when we talk to our clients and we say, okay, you really want to get divorced like tomorrow, I get it. Would you like to pay some maintenance to your wife? Well, I couldn't do that. Okay, well that's fine, but I can't get you divorced in right now until we work that issue out, right? And so that's the issue. But way one is the parties are able to come in and do this. And we have these cases, you know, but they're rare, where people right out of the gates, they decide we don't want to be married, and we got an agreement on it, right? It happens, but I mean, you're talking really a small percentage of cases. Most people disagree on something, right? And we'll break this down in more detail. Two is, the court makes a decision after hearing all the evidence presented at trial. So in family court, you can do a trial. It's in front of a judge, and you have one judge wearing a robe making a decision for your family and your kids, and their decision's final, right? So one attorney who's a judge making a decision for your family. Does that make people feel pretty good? Right? I mean, the dilemma of this, and we'll go through this, and this is the common theme I would just hit with you all, which is, I mean, if you follow judicial opinions, you follow Supreme Court decisions in particular, I mean, you see a lot of 5-4 decisions, right? Courts don't always agree. The way one judge views a case might be totally different from the way another judge views a case, right? You got conservative judges, you got liberal judges, you have judges in the middle. Judges disagree, and that's true in the same courthouse. You know, you could try a family law case in front of one judge, go up the hall, in front of a different judge, and you get a terribly different result. But this is way two. The parties can't agree. Something hangs it up. The only way to end it is a trial in front of the judge. Way three is one party defaults, or to use a sports analogy, forfeit, which means one party files divorce paperwork, serves the other party goes missing in action, doesn't respond, doesn't file any responsive pleadings. And in that case, the party who was filed the case properly served the other party. They can file what's called a motion for default. This is rare in family law. Doesn't happen very often. Most people, especially if they have kids, you know, they're going to do something. You're not just going to go MIA, but it happens sometimes, all right? You just have to be careful because, you know, Missouri, if you serve the other spouse divorce paperwork, they have 30 days to respond. Right? I have clients that have called me, and it's like day 31. Like, Kirk, I've got it on the calendar, I've got it marked off, they're late, right? Let's just do a motion for default, let's end this thing. Well, your dilemma is this, is if you look at the Missouri case law, there's a lot of cases on it. There's a really important case called Cutter-Ascoli versus Cutter-Ascoli, where courts, especially in custody cases, disfavor default judgments when children are involved, right? So if the other party eventually wakes up from their slumber, wherever they've been, and they come back and they want to set the judgment aside, most judges will do it if that party comes back in a reasonable time. So, you know, our advice typically is you can do number 3, but you want the other party to be significantly late. Rushing in on day 31 might cost you more fees, and it might just get tossed anyway. All right, but there's sometimes way 3 makes sense. I mean, here's the deal. When you do a motion for default, let me explain this too, because I know this is kind of abstract. I think what a lot of parties kind of envision is that like these files are just sitting on the judge's shelf, and like the judge has them tabbed, So when it's day 31, like they just pull that file down and sign it and you're divorced, it's more complicated than that. So when you do the motion for default, here's how it works. The attorney has to file a motion for default, right? You then have to renotice it, so you notice it for hearing, you give notice again to this person who's not paying attention. You then have to draft settlement paperwork. If we're the attorneys on the case, we have to draft settlement paperwork, so we still have to go through all the key elements. We got to divide all your property debt, we have to do a custody plan, got to do child support calculations. So we're doing a lot of work, right? And we go into court, and if they don't show, then the judge will sign it. But what I'm telling you is the rule in Missouri 7406, you can set aside default judgments in a lot of cases. I mean, 30 days easy. Afterward, within a year, most judges will set it aside, especially if kids are involved. And so what I'm saying is, in terms of attorney fees, I assume most people don't want to waste attorney fees, right? In terms of attorney fees, if you spend a lot of money to try to hold the other person to fault, and then it gets tossed, you know, see where I'm going with it? And so there's not a bright line rule. Sometimes we file the motion to default just to kind of like, you know, just kind of CPR the other person, kind of wake them up. Like, no, you got to move, you know, you got to move. You got to move, we're going to default you. And that gets a lot of people moving. It's like TV, it's like trial. Like we do divorce trials. I mean, that's the only way you end the case. I mean, if the parties can't agree in the Constitution, I don't get too like abstract in the sky with y'all, but we have what's called due process in this country, which is a right to hearing, right to due process. And so judges can't. I think a lot of people just think the judge can just kind of like bang the gavel and say that it's like, you know, do you ever watch Judge Judy or Judge Joe Brown? A lot of people watch that on TV and they think the judge can just bang down that gavel and that's it, right? But they can't. If the parties can't agree, due process, which means both parties get to put their evidence on, so husband could testify, wife could testify, family members, friends could testify, you have experts testify, sometimes psychologists will come in a custody case. If you have a house, and we're going to go into this, I have an appraiser who comes and testifies as the value of a house. I mean, you name it, but yeah, trials. And so I know nobody wants it, but it happens. But if you don't have an attorney, right, it's not good to sign legal documents.
Right.
In any sense, family law, otherwise. If you got legal papers and you don't know what they are, you need to speak with somebody before you go signing it. But right, in a lot of cases, I think what you're referring to is waiving service. I mean, typically when a case is filed, the sheriff or a process server will hand you the paperwork. They get paid for serving, right? So they want to serve, right? If you're a process server and you drove all the way out to your house and you're not opening the door, right? They go back home, they get paid, right? So you want to serve that too, right? You want to serve that thing too, otherwise you waste all that gas money and that time. So I mean, that's true.
So
they'll hide out in the bushes and you know, they will, you know, they'll get you. Well, I mean, look, if you've been served paperwork, here's what you got to do: get an attorney right away. You got to get in, you got to get to an attorney. An attorney might be able to get you an extension or something like that. You need to get an attorney. Bad things happen when you don't get an attorney. I know a lot of people say, I can't afford one. You can't afford not to have one. You know, as a kid, you go to school and the teacher says, your homework's due Friday. I mean, it means Friday, right? If you try to hand your teacher the homework Monday, those teachers will say, I said Friday, right? And court's more formal, right? So sometimes it amazes me. I mean, 30 days is what the law is, right? And you go, what does that really mean, 30? I don't know. I mean, that's not the way it worked when I went to school. If my parents told me to be home at midnight, and I said, what, it's 12:30. It's close enough, right? No, it's at midnight, right? It's at be home at midnight. So I mean, it's court rules, and you have to abide by court rules. Maybe you luck out and nothing bad happens, but something bad happens, I mean, you'll regret it forever. And so, I mean, you need to get an attorney right away if you've been served paperwork. Way 4 is the parties reconcile. It happens, you know. It just happened in a case of mine recently, a few weeks ago. So the parties decide, dismiss the case and get back together. But I mean, this is really it. Divorce file, going to end one of these 4 ways.